Guys, so today we're going to be talking about estate plans for the diversified investor. So this is all of our investor folks who are involved across multiple types of asset classes. So if you are dealing with short-term, long-term, crypto, note investing, syndications, whatever it may be, this is the place for you. And so specifically today, we're going to talk about what does it look like for you to have an estate plan? What is it comprised of, and why do you need it, and when do you need it? So let's hop into it. A little bit of introductory information here. So here at Royal Legal, we are your one-stop shop. So we operate in all 50 states. We've got our staff and team are distributed across the US, and we have attorneys who are licensed in multiple places. Inside of that, we've been doing this since 2013, and we have helped our investors protect over $2 billion in assets. So we've seen a wide array of circumstances come up. We love to navigate the fringe cases for you, and we're always growing our networks. We've got more information, more resources for you to make sure that your entire structure is completely covered. A little bit about me. My name is Megan Templeton. I am a consulting attorney here at Royal Legal. I am based out of Birmingham, Alabama, and I have a diverse portfolio. So I've been doing real estate, small business, entrepreneur law, for much longer than I've been at Royal Legal, but I've been with Royal Legal for about 4 or so years and have absolutely enjoyed it. I think what we do here is not only valuable, but it's just a heck of a lot of fun. So, particularly passionate about this topic of estate planning because I have seen it gone poorly so often before in my previous practice. And so want to make sure it's something you guys fully understand so you can protect not only your personal assets, but also those business assets and carry on that generational wealth. So the first question we're going to ask ourselves is, do you need an estate plan? There are some common myths we hear a good bit about estate plans that we want to walk through and debunk for you. So first one that we hear a good bit about is, I don't have enough for it to matter. My assets are not numerous right now. I may be young, or I may be starting over, or just maybe growing my assets, but I don't have enough right now to really worry about an estate plan. Second one is, I don't think it's for me. I don't have anybody that I'm really worried about providing for. Traditionally, people have looked at estate plans for people who are married or maybe have kids or someone that they need to provide for afterwards. And so, if you are single or if you're not in that place yet where you have got an extended family you're wanting to provide for, you may think it's not for you yet. Third is going to be the person who says, I don't really care what happens. I'm not concerned if the government has control of my assets. I'm not concerned if, all of this wealth I've built my entire life, I don't really care what happens to it afterwards. I'm not going to be here anymore. So what's it matter? Fourth is going to be this idea of it is complex. It's difficult. It's scary. I don't know how to get into it. And that kind of relates to the fifth one we hear, which is it's expensive to create and maintain. So, now we're looking at, could it be hard? Is it going to be expensive? What's the burden on my life to get this going? Is it worth the payout I'm going to get? So the benefits that we use to combat that. So one is going to be this idea of stable wealth growth over time. So you're working for these assets. You want to make sure they continue to grow, but they also can be passed down in a way that is going to maintain the integrity of those assets. Two is creating a legacy that matters. I know this is one that's talked about a good bit here within our Royal Legal team, is doing today what is going to have a lasting impact for tomorrow. And so inside of that, you work your entire life to build your business, to build your personal assets, and you want to make sure that those are used in a way in the future that you intend for them to be used in the way that your legacy you want it to go. Third is protecting your loved ones. So even if you necessarily may not have kids right now, may not be married, you might have parents, siblings, close friends, someone that you want to provide for, protect, and care for. Fourth is protecting your assets and wealth. Like we've hit on a couple of times, you don't want to spend your entire life working towards a goal to have that goal not matter and not be able to have those assets go in the direction you want them to go. Fifth is the idea of creating and maintaining anonymity. So that is a small component of estate planning, but it's definitely achievable, and it's something our team can work with you to ensure that you've got that anonymity in place. You will hear us here at Royal Legal talk about anonymity a good bit because we do think it is an important layer of asset protection and wealth planning. And so inside of that, anytime we can add it into the structures and the tools that we use, we're definitely going to. In estate planning, there's a lot of opportunity for that. So now we know, when do I need to start thinking about an estate plan? What myths are there around it? What are the benefits of it? So when do you get an estate plan? Well, if you are somebody who says, I don't mind if the government takes my money, I don't have any assets, my net worth is less than 50,000. I don't have a business. I really just don't have a lot of activity going on that I'm too concerned about passing on. Estate plan may not be a good move for you right now. But if you're somebody who is really concerned about having your wealth go on to future generations, and I'm not talking maybe just one line down, let's go down future lines as well. Or if you're someone who doesn't want the government to control your wealth when you die, you want to make sure that you have control over that. If you want to protect your family from probate court, or if you've got 50,000 plus in assets or own a business, these are all good times to start thinking about having that estate plan. And I really think from a holistic approach is this idea of what am I working for today? Who do I want that to go to? And do I care about how that happens? And if you're answering yes to those, then it's a good time to start thinking about getting your estate plan in place. So now we talked about what are the benefits of it? What are some myths that are untrue about it? When do I need to think about having it? So let's get into the technical pieces of what exactly it is. So an estate plan is going to consist of a couple different items in order for you to be able to say you have a fully comprehensive estate plan. So I think they can be grouped into a couple different categories. The ones that we've got listed here on this top line of the chart on the slide deck are going to be your power of attorneys. And that is one layer, is the ability to have these power of attorneys. And what those are useful for is to have someone step into your shoes and take actions when you cannot. So inside of that, there are two types that we focus on. One is the durable power of attorney. And so that's going to be the document that names individuals to make your financial decisions for you if you're incapacitated or you have a disability where you can't speak for yourself. So the durable power of attorney is financial. When you're thinking about this document, be thinking things like, this is a document that's going to allow someone to continue running my business. They can sign contracts, they can purchase properties, sell properties. They can go to the bank for me if I need to. These are the items you're going to use that financially focused durable power of attorney for. Flip side of that is you also want to have a medical power of attorney. And that's going to be the document that names individuals to make your medical decisions for you if you can't. So this is going to be the one that if you want to make sure you can specify that it's your sister who can make those medical decisions, and you want to specify exactly which medical decisions she can make, you're going to want that medical power of attorney in hand. Related to that and below is you're going to have some more medical type related documents, but these are more going to be information related. One is going to be your HIPAA authorization form. This is the form that's going to tell your medical providers which individuals have access to your medical information and records. So if you want to ensure there's someone who may not statutorily have a right to any information about you, you want them to be able to pull those medical records for you. HIPAA authorization is something good to have on file so it can be provided to your medical team when needed. Next component is going to be the living will. Living will is the document that's going to declare your wishes with respect to life prolonging treatments and procedures. So it's going to be another one you're going to have on deck that you're going to hand to your medical provider. Down here at the bottom, you're going to see things that I think really fall more into the operational pieces of the estate plan. So the nitty gritty, the meat of it. One on the left-hand side here, we've got listed our pour over will in conjunction with our living trust. Now, those are two separate documents, but because they work together, and we'll walk through how they do so in just a moment, you'll often hear them joined together as one type of item. They are two documents, but they do work together very closely. So let's start with this idea of the living trust. I think that's the foundational piece. The living trust is the document that you're going to detail who your beneficiaries are, so who your assets are going to go to, what your assets are, and how those assets are going to go to your beneficiaries. You're also going to list a trustee, and that's going to be the person in charge of doing the administrative pieces of your distributing your estate. So you've got the living trust. That's the meat of it, where you're really talking about, here's what I have, here's who I want it to go to, and here's how I want it to go to them. And here's who's going to oversee that. So your living trust is going to be very comprehensive. You want to make sure it includes all of your assets. So you may say then, Megan, well, what if I forget one? Or what if I don't update my living trust in enough time before something happens? Am I out of luck? So that's where the second portion of this comes in, the idea of the pour over will. Like we said, they work in conjunction with each other. So what the pour over will does is it says anything that hasn't been included in your living trust or isn't up to date, this is our catch-all document. The pour over will is going to pour that asset into your trust at the time of death. So it's our CYA document. It's your catch-all. It is to say that if something is not specifically enumerated, we still want it in there. We're going to pull it in through the pour over will. Flip side of that is also going to be the declaration of guardian. So that's going to be the documents who will be your guardian of your person and your estate in the event of incapacity. So this is going to work in conjunction with the idea of a trustee and executor. You may also see declaration of guardian related to the idea of a declaration of guardian of minors. That's going to be related to who's going to take care of your kiddos until they reach the age of majority. So these are the documents that we really consider the foundation of a comprehensive estate plan. and that they are very flexible in how they can be modified, how comprehensive or complex they can be. So that is going to be tailored to your specific circumstances, but at a base level, you need some version of all of these documents. So let's walk a little bit more into what the various aspects are. So you'll see this chart is our death protection type of chart. It's talking about this pour over will versus the living trust. So here on the right hand side, you'll see that we've got the living trust and list that, one, it's going to keep your assets anonymous because that trust is a privately held document. It is not publicly recorded in most cases. And so inside of that, whatever you have listed in that document, it should not be public knowledge unless you have consented as such. 2 is this idea of avoiding getting caught in probate court. So the trust does skip the probate process, where if you only have a will, then you're going to have to go through probate. Now, if you're not familiar with probate, it is the court's process of administering an estate. It is very costly and it can be very time consuming. I've seen them take upwards of 2 years and cost upwards of $50,000. So avoiding probate, I think, is imperative. As your family is going through this grieving time, you want to make sure they're not having to sit through that process. So the living trust is a good way to do that. 3rd is that you're going to be the ultimate owner of everything. So the living trust is a revocable trust. It's going to ensure you maintain control and ownership of those assets while you are living, and at your time of death, that trust does become irrevocable. And so at that point, you're going to be able to dictate who the ultimate owner of those assets are through the language listed in that trust. Next is going to be you get to choose who gets your money and when instead of the government. So if you pass away without any type of estate plan in place, the government is going to use its own formula that can vary by state, but it's going to go through the intestate laws to figure out where your assets are going and how they are doing so. So I wouldn't want to leave it up to a government formula to figure out what's happening to my life's net worth. So I would make sure I want to dictate it inside a living trust. Last one is going to control the process during your life and after. So like we talked about, it is a revocable trust document. So it's got implications now that can be amended, but then it also does become irrevocable when something happens to you. So it's locked in. It's going to control that process there as well. Relatedly, like we talked about, living trust does go hand in hand with the pour over will. Pour over will is going to be anything you forgot to put into that living trust. It pours it over. Next set of documents, like we talked about, is this idea of hospitalization protection. So you've got the HIP authorization, which, like we said, is going to allow your medical providers to share your information with those you want it shared with. You got the healthcare power of attorney, which is going to dictate what healthcare decisions can be made for you and who gets to make those decisions. And then you got the durable power of attorney, which doesn't really fall under the hospitalization as much, but it is going to revolve around who can make financial decisions for you and what decisions can they make. So like I talked about, these documents are extremely flexible. So inside of that, if you've got certain decisions around either finances, medical care, or anything like that, that you don't want someone to have the ability to do. So if you, for example, you want your durable power of attorney, whoever that person may be, you want them to be able to go and purchase an asset but not sell one, we can dictate that out. We just need to tweak the language inside of it. So now we've gone through those different parts of an estate plan. So what happens beyond the estate plan? What other tools do I need in my back pocket to ensure that my personal life and my business affairs are fully covered and I have a comprehensive overview of what I'm doing? So this is like what we like to call our asset protection, tax, and estate planning map. So these are some items that you may want to consider putting into your circle of tools you're using. They may not all be applicable now, but it's something to keep on the horizon that you may want to use later on. First, we've got listed is that idea of the estate plan. And you'll see throughout this list some components of that, things like the living trust, as well as, you're going to be looking into having those power of attorneys as well. Number 2, we've got listed as the offshore trust. Offshore trusts come into play when you are someone who has got a very high net worth and you're looking to make sure your tax burden is a lot lower. And you're also having those offshore protections. So that's something that if you've got about 20 million assets or plus, start having a conversation with us about it. 4th is going to be your traditional LLC. So that's going to be something you're going to operate your day-to-day business affairs out of. It is typically a shell LLC that does not hold assets, but is your public-facing entity for all operational pieces. I'm going to skip down a couple line items and go ahead to the parent series LLC, which you'll see below. It goes down into the child series, land, trust, and property. So that is going to be your asset holding structure. Now, it doesn't have to be a series LLC. It could be something like a DST, a Wyoming trust. There's a couple ways we can structure it, but you want some type of asset holding company that purely holds your asset. It is not public facing. You use your traditional LLC, operational LLC for that side of it, but you've got an asset holding company set up for you. Inside of that, we use anonymous trust a good bit with our structures. You'll see a couple different types of trust. You'll see a land trust, which is what's going to hold title to a property, but it's going to give you anonymity on a deed. You'll see an anonymous ownership trust, which is going to own your LLC or DST structure so that your name is not listed on any formation paperwork that's publicly filed with the Secretary of State. So we use a lot of these things to add in anonymity that go alongside of the liability protections. And then you'll also see on this list a couple of items related to retirement investment vehicles. So you've got the idea of the solo 401k and the self-directed IRA. These are going to be vehicles that are going to help to minimize your tax burden. They're also going to give you that retirement planning you're looking for. So a couple different ways we can structure those. There's also things like S corporations, C corporations. There's a lot we can do to round out your personal structure. So best way to figure out when to get these items and what's a good fit for you now is to meet with one of our advisors. But this chart will give you an overview of the things to start thinking about. Here at the back, we've got a couple of frequently asked questions about estate plans. So one is going to be, if I've got my living trust in front of me, so your team has drafted it, the attorney you're working with is drafted it, at the end, you've got these exhibits. These are going to be blank pages, typically that's going to be lined paper. What do you do with that? Is this something that your attorney needs to be doing? Do you handle it personally? Does your spouse, partner, whoever you may be with handle it? So the exhibit, the purpose of it is for you to list out your assets on that exhibit list. So it is something you want to keep up to date as much as you can, and you want to be as detailed as you can. So it is something we recommend that you and your partner complete in conjunction with each other. And if you want to loop your attorney in, they absolutely can assist with this, but they'll need input from you on exactly what needs to go on that list. Question 2 is, what does a comprehensive estate plan include? And those are going to be the items we've just walked through. So the pour over will, your living trust, your 2 types of power of attorneys, healthcare and durable, your HIPAA release authorization form. And then also you've got the idea of your living will in conjunction with your declaration of guardian. Excuse me. Third, should we make copies of the estate plan? Who should get those copies? I think a good rule of thumb is to have at least 3, if not 4 copies floating around. One is you're going to want to have your original signed copy in a fireproof box in your home, and you want to make sure that someone knows that is there. Typically, I recommend telling the trustee of your living trust or the executor of your will. That way they know exactly where in your home they can find a copy. 2 is in a safety deposit box at your bank. So go ahead and make a copy of that signed one, put it in there, and let your folks know where they can find it. 3 would be a copy with whoever is invested inside of that document. So like I said, your trustee, your executor, go ahead and give them a copy to keep on hand in the place of their choosing. So it may be their personal safety deposit box. Somewhere when something happens, they know how to easily get a hold of that document. 4th option you could do is also to ask your attorney to maintain a signed copy. So when your attorney completes this document for you, they're going to send it to you for signature. So they're going to have an unsigned copy by default. But once you sign that, I go ahead and return it to your attorney, ask them to keep a copy on file. All of the documents you have should have attorney contact information listed in them as well. So whoever has to take actions on your estate plan can take a look at the documents that were drafted for you, find the attorney name, give that attorney a call if they need to. So I think it's a great rule of thumb just to have multiple copies around and to make sure folks know where those copies are. 4th is, can you make specific wording in your living trust if you want to make sure a specific person is listed? Absolutely. So we've talked a couple of times about how these documents are flexible. So we can amend these documents, customize them to accomplish your specific goals. That includes listing who you want to be involved, what assets are involved, and how those assets are going to be distributed. 5 is, what happens if I sell an asset? Here at Royal Legal, the way we set up our structures is we've always got the living trust at the top of it. That ensures that anything we put into a structure flows through to your living trust. Anything that goes on inside of that structure below it, if that's purchasing a new asset or selling an asset, is going to have an impact on your estate plan. So if you sell an asset out of your structure, it's automatically removed from your estate plan. You do not have to update that estate plan document. So it's really easy to maintain. If you have worked with someone outside of Royal Legal, I would also be asking those questions about, how does this connect with my estate plan? How do I make sure I keep this up to date? Most attorneys are going to use some type of integrative structure where it's low maintenance to maintain it. So what that may be connected by having an owner of your entities, or it may be simple. They might have a process for updating exhibits. There's a couple ways to do it, but it's definitely an involved conversation you want to make sure you're having of, how do I maintain these and keep it up to date? And the structures we use, it's a very simple process to do so. So here at the back of the presentation, you'll see we've got a couple of reviews. I highly recommend reading through these. This will give you an idea for how folks interact with us here at Royal Legal, the type of services we can provide, and the impact it's had on their businesses. We've also got a case study here from Scott Sutherland, who talks about exactly how Royal became his partner and the ways we were able to assist him in growing and protecting his business. And then here at the very back, we've got our Royal Legal quiz. So the quiz is the best way to get connected with our team and make sure the information and resources you're receiving are tailored to you. So that quiz is going to ask a couple questions about general contact information for you. What does your portfolio look like? What information can we get to you? What are you looking for? What are your goals? So inside that, our team does review that, can connect you with the appropriate advisor, and also get you any of the written materials we can get to you, so you can do some education pieces that way as well. So I highly recommend it. Like I said, it is the best way to get plugged in, because we want to make sure we come alongside you and provide you with everything you need to be successful. So thanks for listening, guys, today. I hope this presentation was useful for you. We'll have this slide deck available as well, so you can click on that quiz link. As always, please make sure you're joining in on our shows whenever you can. I think there's a lot of networking and educational value inside of them. And then we've also got things like our Discord channels, where you can connect with other investors outside of these meetings. Those Discord channels are available at all times as a general chat function. So thanks so much, guys. Hope everyone has a great day. All right, team, I'm going to stop sharing my screen. Any questions that came out of that? I know, like I said, I know it's duplicate information, but anything that came out of it's fresh for somebody else.
So a bridge trust, how do we know if we want or need one of those?
So I am not the bridge trust attorney at Royal Legal. Scott typically does those, but I will tell you, I think his base level is you want to have a net worth that's up above 15 to 20 million.
Wow. Okay.
Yeah.
Well, that's something to aspire to.
Right. Yeah, that's because they can be so expensive and so complicated to set up that most of the time you really want to make sure you're in a place where you've got the value to really make that worth it. So like I said, I have very limited knowledge about it, but if that's something you're really interested in, Scott would be a good resource.
I hope to be interested someday.
Right. Me too. Okay, guys. Well, I do have another call at 1, so I'm going to hop if there's nothing else. But like I was saying earlier, I really, really appreciate you guys always showing up, being so engaged. These calls are a lot of fun for me. I enjoy hopping on and getting to interact with you guys. I know in the kind of attorney role I was serving previously, I didn't get quite as much free-flowing interaction with clients. So this has been a lot of fun. I'm not going to give my normal spill because you guys all know when the shows is, how to register, how to get the recordings, where the Discord channel is, but you know, keep chit chatting with us, and then I'll see you guys next week. I hope you have a great weekend.
Thank you, Megan.
Have a
Thanks, Megan.
Thanks, guys. Bye-bye.
See you all next week.